Hey guys, thanks for joining today. We're going to talk about one of those things that everybody needs to know about, but nobody wants to know about. And it is kind of a specialty or a focus of my lovely wife, Jasmine. So, Jasmine, it is nice to see you today.
It's nice to see you too.
Absolutely, it feels like it's been years,
It's only been a couple of hours, honey.
but every moment feels
Oh,
like
yes.
another year. So, all right. Well, I have a couple of really incredibly bad jokes.
Can't wait.
Oh, I'm sure you can't because, a little boy asked his father, "Daddy, how much does it cost to get married?" Father replies, "I don't know, son. I'm still paying."
Oh. Did you choose that one just because you're doing this with me?
Oh, 100%. Absolutely.
Oh, great. Great. Love that. Love that.
My wife just found out I replaced our bed with a trampoline. She hit the roof.
That was the joke.
These are all like one-liners, so I don't know what to expect.
It's so bad.
I know. No, I absolutely go with the most hilarious things ever. A stock
Okay.
market crash is worse than a divorce. You lose half your money, and your wife is still around.
Oh. Oh, that's awful.
I know. Well,
That's awful.
here's one more of those most amazing jokes that there ever is. Uh, you know, if you get divorced, statistics don't lie. 100% of divorces start with marriage.
Oh my goodness.
So don't say I didn't warn you.
No, those were horrible. Those were horrible. But you know what? Can I tell one? Is that okay if I tell a joke?
Oh, please, absolutely do.
Okay. So, my delivery is not going to be as nearly as good as yours, but you know how in the Bible, the story of Job, where God was testing Job and took away, all of his money, all of his wealth, all of his children. The one thing that God did not take or interfere with was Job's wife.
I guess you got to be there. Yeah, no, I know. I'm total fan.
Well, you
That
know
was
what? It's okay.
hilarious.
So apparently we're just a family of people telling bad jokes.
Bad jokes and attorneys. So,
Mm-hmm.
it is nice to have a wonderful attorney, Mrs. Jasmine
That's
Dodson
correct.
here.
Mm-hmm.
So that people don't just think I'm your wonderful, most awesome husband that there ever was in husbandry.
Mm-hmm.
Could you take a few minutes and introduce yourself?
Yes. I am Mrs. Jasmine Dodson, and I am Nate's wife. We've been married for um almost 2 decades now at this point. It's been a really long time. We met while we were both in law school, and Nate started the law firm Dodson Legal Group, and then I joined a few years later to kind of do my own thing. And now we've been doing Dodson Legal Group for how long have we been doing Dodson Legal Group? Do you know, hon?
Almost as long as we've been married.
Almost as long as we've been married. Yeah. So um, Nate does all of the legal work that is more paperwork and behind the scenes and contract type. Well, he used to.
I
I don't know
got
what he's
people for
doing
that.
now. Um,
They really don't
and
do anything. It's fantastic.
it's wonderful. Um, And so I do all of the things that essentially touch and concern people. So I used to practice family law. I don't practice family law anymore, not much of it. I do some family law mediations.
So this is where it gets to be really fun. Like I've always had this saying, if we ever got divorced, I understand I'm going to lose everything, gone. But I know money really well, so Jasmine has to find it first.
Yeah, I'm okay. I guess.
Good luck with that.
Yeah, that's fine. You can keep it all, honey. If we're got,
this is
family,
recorded. Everybody
and it's
knows.
Live. Everybody knows.
Write
now.
It down.
You've just made an admission to all of.
You just promised to give me everything.
Oh yeah, you can have it all, honey. That's okay. You can have
Right,
you can have whatever.
Not get divorced.
Whatever. That works too.
I mean, if we made it this far, I'm not too worried about it.
Stay together for a little while longer, at least. So Nate does all of the behind the scenes stuff with money and contracts and things, and I deal with people and people's emotions and people's feelings. And family law had a lot of emotions and feelings, and it was very personal. There's a saying that people who are involved with family law see the best people at their worst, and people who deal with criminal law see the worst people at their best. And that, it's kind of true. But I've stepped away from family law to deal more with the elder law side of things, which is includes guardianship, probate, and estate planning. And of all those three areas, I think estate planning is probably my favorite, because I love to, as my husband can tell you, I love to organize people and get everyone organized. And, and I also enjoy teaching. Oh yeah. I love planning. My favorite thing to do is planning trips. We go on a trip, I plan everything. And
I get to pay for it and show up at the right time and place, and we go. It's phenomenal. That's great. Why we work. That's
why it works. Yeah. It's a symbiotic relationship. Yeah. I do really enjoy estate planning, and I also enjoy teaching about estate planning and educating individuals on, the different types of estate plans that could be very beneficial for them. And sometimes it's just a 2-second, hey, this is what you need, make sure you get this done. So estate planning doesn't have to be painful. If you do have larger estates, then yeah, you definitely want to take the time to put together a plan. But even if you don't have a lot of anything, it's really nice to kind of get certain things down. So let's see, I've been doing estate planning probably since I joined the Dodson Legal Group team, and we started in Nevada and migrated over here to Texas. And so now we are Texas lawyers at this point in time. Mm-hmm.
I love it. Well, you know what? So just to kind of set the stage and why estate planning is so unbelievably important, not just for you, your family, your parents, taking, how to work with them, but also, we focus on money on my side of the world. So it is also about protecting it, asset protection. I'll talk a little bit about that, but also making sure that you're taken care of, your family's taken care of. And if you're raising capital, doing deal, working with investors, this is one of the most important things that you can help them with, is making sure that everybody is planning for their future, planning for and with their family. And then to take it one step further, when you're working with a client, an investor, whoever, when they start explaining what they got, you got to understand this stuff. So with that, I'm actually going to shut up and step back so that my lovely bride here can teach a thing or two for 10, 20 minutes or so. And then I'll pop right back on and get into a little bit of the asset protection. And then pretty please, everybody, you have questions, something doesn't make sense, throw it in the chat. This is all about your time, and we want to make it as valuable as possible for you. And with that, I'm going to go ahead and shut up.
It's always nice when your husband voluntarily just decides to, hey, I'm going to shut up. Aside from all the spouse jokes aside, let's kind of get talking about some a little bit more serious issues about estate planning. I don't have any fancy slides or anything because I really just kind of want to make this personal for everyone that's watching. Now, I did explain that I am an attorney who's licensed to practice in the state of Texas. I'm also licensed to practice in the state of Nevada, but the specifics that I'm going to be talking about today are based on my experience as an estate planning lawyer within the state of Texas. So if anybody's watching from a different state, my advice would be to, take some notes. And if you have questions that are state specific, reach out to a local estate planning attorney there and see if there are some similarities or if there's something different in your home state that will allow you to maximize kind of some of the things that we are talking about today. And with that, I'm going to try to keep it as general as possible because some of the information that I'm going to be speaking about today does, transfer across state lines. So with that, let's kind of get into the most important question that I get is, when do I need to have an estate plan? And the answer to that question is, if you are over the age of 18, you need some type of document that will allow someone to act on your behalf in the event that you cannot act for yourself. This is especially important for my students. If you're in college or if you're a parent and you have kids who are in college who are over the age of 18, you definitely want to make sure that they have at least a power of attorney or a medical power of attorney. Let's talk a little bit about what those documents are. Now, a power of attorney is a document where you designate someone to act on your behalf as it relates primarily to banking and business transactions when you are unable to act on your own. So this means that for my listeners that have college age kids, if something happens to your child, even though because they're no longer minors, they're technically adults in the eyes of the law, this power of attorney would allow you to access their banking information. It will allow you to talk with the schools that they're going to about, anything that you need to talk about. If you need to transfer any assets like titles to vehicles, those types of things, this document, this power of attorney will allow you to do that. Now, for my adults and my older individuals, this document also will allow you to act on behalf of someone in the event of an incapacity. With my elderly individuals, this could be Alzheimer's or dementia. For younger individuals, it could be something as serious as a traumatic brain injury. But this document, this power of attorney, will allow your loved one to be able to step in and continue paying your bills, maybe access your bank account to in order to continue, like I said, continue to pay your bills, or if you need property sold or transferred in order to pay for your care. This power of attorney document will allow them to do that. So that's why a power of attorney is so important for anyone over the age of 18.
So let me ask you a quick question.
Sure.
I mean, you say that everybody needs it, but let's be honest, absolutely nobody has it. If you're a parent and your kid is in college, should I be having our kids' power of attorney just so that anything happens? Or what if they go to the hospital? Who's helping? What happens?
So, actually, a lot of people think that, you can download this power of attorney form online and, you just write a power of attorney, but it is one of the most abused estate planning documents that are out there. And to answer your question, it is starting to become more common for parents who are sending their kids off to college to go ahead and get this power of attorney in place, because if they need to access any records or banking information for their kids, this document is there. And the same can be said for a medical power of attorney, which is very different than the power of attorney that we talked about, because the first power of attorney that we talked about only allows for business type transactions. You cannot take one of these power of attorneys and go into the doctor's office and try to use that to make medical decisions for someone. That's a separate power of attorney. That is a specific medical power of attorney that will allow someone to make decisions for you regarding your health care, that if you cannot make these decisions for yourself. So that document is equally as important, especially if you're over the age of 18, because you want you want to designate someone to be able to make medical decisions for you in the event that you cannot. And while hospitals, I know in the state of Texas, they do default to next of kin to make decisions, but sometimes that next of kin person isn't the one that you want to make these medical decisions for you. And like I said, it's especially important for my parents that have kids in college, because if your child is in college and they get hurt and have to go to the hospital, you're definitely going to want to be able to have this authority to make decisions for them.
Okay, let me ask you the absolute most important question.
Sure.
If I'm go to the hospital, I'm in a coma, I got in a wreck, do you get to pull the plug and make that decision? Or
yeah, you signed the document already for me to do that.
Okay, so there's actually a huge risk, because I know that whether it's you or our beautiful girls, like the first thing they're thinking about is, how can we quickly get dad out of the way?
No one's thinking that. No one's thinking that. That actually, that was a nice segue into the third document that I wanted to talk about. That is a very important document. And this is the advance directives. So an advance directive is, it's not a DNR. A DNR is a do not resuscitate order. And, there's two different types of those. There's one that's in hospital and one that's out of hospital. We can talk about that a little bit later.
Is that the pulling the plug document?
The DNR is the one that says, I don't want to receive any medical care. If I flatline, that's it, I'm done. The advance directive, that's the pulling the plug document. So the advance directive is where you write down what your desires are. You're essentially that's what advance directives. You're telling people, if I can't make the decision as to whether or not I want to stay in a coma, put me on a cryogenesis machine, whatever new technology they're going to come up with to keep you alive forever.
Brain freeze.
If that's not what you want, you want to send me to the taxidermist and, put me in a high five position so I can high five my family and friends. This is that document. It's not that specific,
I expect
but
to be in that armchair next to your bed for the
that's
rest
just creepy.
of your days.
No, we're not doing that. We're not doing that. I've already drafted the documents and you've signed it. That's not in there.
Did I sign the pull the plug, or did I sign the, I want to go ahead and make it?
No, you signed the pull the plug document. That's what you signed. It's on.
Cool.
It's in your forms. If you want to change it, I'm happy to. Let me know. I'll prepare some new documents.
We got a quick question. Okay. And I don't know if this applies to right now or not, but I'm going to go ahead and ask you anyway.
Sure.
What about if you're the sole heir? Do you automatically get the right to decide for your parents if they have an issue, they're in the hospital? Is it me, or is it their spouse? Is it their brother or sister, parents? Who decides in those cases?
That's actually a very good question.
Thanks, Kennedy.
Of course. But I want to kind of just say nothing is automatic. Whether you're the sole heir, whether you're, the only child, whether you're, nothing is ever automatic. And that is a common misconception in estate planning. And that leads to a lot of litigation and people receiving assets that you might not have wanted them to have. Just assuming that something is going to be automatic is leads to some estate planning situations that are not unintentional. So nothing is ever automatic. You want to make sure that whatever you want, whatever your desires are written down in the proper document and provided to the proper people. So I know even in the state of Texas, some people think that, oh, I'm married, my spouse will automatically own my house if I die. That is not necessarily the case.
So if I get divorced
Why are
and
you
then
talking about
I
divorce?
get
Are you
yeah, I
somebody needs
have
to be?
that ex-wife. You didn't know about that?
No, you don't have an ex-wife.
Okay. Well, if I did have an ex-wife,
Sure.
does she automatically get cut out of stuff? And you're added now that you're new wife number 2? Or like, does something have to happen for you to have the right to act on behalf of my ex-wife that none of us like?
So let me tell you a story about a case that I had. So I had a situation where I was dealing with the second wife, and her husband had passed away, and he had a will. And in his will, he left his real property interest to his current spouse, who's now widow. However, his divorce decree from his first wife only entitled him to a certain share of the real property that they had been living in for a substantial period of time. I don't remember how long it was, if it was 10, 20 years, but new wife and deceased spouse had been living in the house for a substantial period of time. He passed away. She thought, okay, I'm going to get this house that we've been living in. But then the first wife showed up with the divorce decree that granted her an interest in that house. And so she said, I want my share before anything else is divided. So, I believe we ended up settling on something and buying out the initial spouse. But, it's situations like that where no one sits on anything. Everyone sits on anything. No one says anything about proper title or ownership or anything, because no one digs deep enough to find out, okay, do I really own this and how much do I own? So for my blended families out there who have been through divorce and, maybe have a divorce decree that transfers property where the property may not have effectively been transferred yet. That interest may still be out there and it may still be in existence.
I just wanted to comment that you have like the best stories. And I mean, this has been for the entire time that we've worked together. And I know that I bring home a story and it's like,
it's so dry.
You make fun of me. I know. Yeah. It's like, well, there's
oh my goodness, can you believe that the class A preferred stock, blah, 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 blah. And then the B stock, blah, 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 blah. Yeah, it's great.
Money is exciting, commas and what does it mean?
Yeah, it's great.
But I would, I know everybody, because you have amazingly crazy stories, to the extent that you can share, of course, that client confidentiality, unbelievably important for attorneys. But my God, lady, share with us some of those crazy, crazy stories that I know and love.
Oh my goodness, I have so many stories. I don't know what people want to hear about. I got lots of the family law stories seem to be the juiciest ones. But the probate and guardianship ones they're pretty out there too. Some of those can be pretty outrageous.
Issue that people are afraid of is getting written out of a will, or somebody else is getting written out of the will, or what happens when the families start fighting. These are real live issues that people deal with. And they don't really understand how ugly it can get. So if you have something along those lines, that would really be beneficial to anybody that is paying attention. Plus, it's way funner than any story I've ever had.
Well, okay, so here's a good story to remind you to go ahead and get your estate planning done while you have full capacity. And what the worst as a probate attorney, and people that don't know what probate is essentially taking someone's will, submitting it to the court so that it can be administrated in accordance with the terms of the will, to make sure that what you write down in your will gets to those people who you decide you want them to receive things. The worst probates are the ones where someone has passed away, and within the last few months of their life, they have several different wills. And the general rule is the last will that's written is the one that supersedes the rest of them, because there's language in the will that says, any of my other prior wills I revoke by this document. I received one where it literally looked like the signature started off as a proper signature and then just kind of trailed off along the side of the page. And so, I kind of looked at that will and the person who presented it to me to be sent to probate. And I said, there might be some problems with this will, because it doesn't really look like the signature of the person who's signing it. And in addition to it looks like they fell asleep as they were signing it. Now, does that in and of itself negate a will? No, it doesn't necessarily, but it does raise some questions as to, did this person, number one, have the capacity to sign a document? Did they understand what they were signing? Did they intend to sign it? Or, did they intend to make it look like they weren't trying to sign this document? So lots of good issues happen towards the end when you don't plan and you leave it till the last minute, and you have people, shoving wills in front of your nose while you're in the hospital asking you to sign things.
So I just, only because you bring up capacity, and I don't know if everybody really knows what capacity, I don't even know what capacity means.
I know.
However, I had a goofy story, but please want you to explain a little bit more of what that actually means. So I had a trust being signed. It was when we were living in Las Vegas.
Oh, I remember this one.
Oh, yeah. This guy comes in and, his past business was in recycling and trash out there in New York. And now in waste management. That's what it was. Now we're in Las Vegas, and he brings in his father, who is this little guy, and he's signing a trust for many millions of dollars for our client to go ahead and manage. And the big concern was, does the guy have capacity? Does he even know what's going on?
Yeah.
May have been a little bit questionable. However, this guy, he brought in a psychiatrist.
Oh.
The psychiatrist actually to interview dad and make sure that he's all well and good. But he also brings 2 massive bodyguards to make sure that everything is done properly. And so that you had this little old man, this psychiatrist, just there to give advice.
Yeah.
With these 2 huge guys just standing right behind him.
Well, that is probably a little extra. You probably don't need to have all of those people involved, because these people then become witnesses. They become witnesses to the signing. And that's not necessarily a horrible thing, but, nowadays we are in a digital age, and a lot of these things can be recorded. You can have a video documented evidence of what happened, what transpired. There is the state of Texas has a, suggested capacity questionnaire that you can ask. You ask questions like, do you know what day it is today? Do you know your name? Do you know who the president is? Do you know which county you're in? Those kind of basic questions. So capacity comes down to whether or not the person knew what they had and who they wanted to give it to. But then there's the other question of undue influence. So you talk about capacity is one thing, but undue influence is another suggestion. So I had a situation that was a guy came in and his daughter brought him, and I try to talk to my clients. I have them, whoever they come with, I have them step outside of the room. So I make sure I talk with the person on their own. And I say, hey, are you sure this is what you want to do? Do you understand? Who do you want to leave your stuff to? Who do you want in charge? And this and that. And so in this particular instance, I met with the guy. I had his daughter wait outside in my lobby. I talked with him. We got all of his documents and stuff sorted and signed. And then about a month later, he comes back in and he says, I want to change everything. My daughter made me come and I felt kind of obligated to give her some stuff because she's the one who took me, but that's not really what I want to do. So, it was, even though this guy was not necessarily overtly unduly influenced, like, his daughter didn't, sit in the room with him and make him sign over everything, but he felt enough in and of himself to say, I felt obligated. I was influenced by her being there and I wanted, her to have these things, but now that she's gone, I want to change it. I want to make it say these types of things. So in that instance, he had the wherewithal to know that, this isn't what I really wanted to do. And he came back and changed it. Now that doesn't always happen. There are several cases where someone is unduly influenced to sign an estate planning document to give things to someone that they normally would not have given them to. And, undue influence can overturn a gift and a will.
What does that mean? Just so I understand, what's undue influence?
Undue influence is essentially when you are, well, in the name influence, you are getting somebody to do something that they normally would not have done, but for your actions and influencing them to do so. So, whereas, like our kids, getting them to take a shower every day, if it wasn't for our influence, they would not shower every day. So not all influence is bad, but, if we were trying to get them to dress a certain way or be a certain way that would be outside of their character, I think that might be, okay. I think that's probably decent parenting. But when it comes to getting an estate plan, if you are pushing somebody to sign some documents to put you in charge of something that would benefit you, that they normally would not have done, then that might be considered an undue influence.
Okay, well, let me ask you this, and I really will apply it to estate planning. But since you brought up the kids, with our oldest, I wrote out a contract when I think she was maybe 5 years old that she would not date until she's moved out of the house, at least 18 years old. Absolutely. And I gave her candy and $5.
Correct.
Would that have been undue influence that I gave her something to sign it?
So aside from the context of minors can't enter into contracts, because you gave her something in exchange for something else is not necessarily in and of itself undue influence, because you can enter into a contract to provide somebody with something when you die. It's called an executory contract. But it has to be in writing. It can't be a verbal or an oral contract. You can give something up in exchange for something else, and include that in a will. That is totally okay.
So let me ask you this, another question from the chat. That there are these online websites that you can just do it yourself, DIY wills and trusts, and we haven't even talked about that yet. Or the other option is seeing an attorney. Are there times that it's like, just go online, have some prepared versus actually seeing an attorney? When does it make more sense to do one or the other, or is there always an answer?
So, when people download online forms, I cringe, because sometimes I have to probate those online forms. And I received one not long ago where someone downloaded a form and they filled out their will and they had it, it was signed properly. There were two witnesses. There was a notary on the signature. They had, revoked all previous wills in there. But the one thing that they did not include was they did not name a beneficiary for their estate. So it checked most of the boxes, but the most important box remained unchecked. So we had a will, proper will, with no beneficiaries listed. So it's things like that to where, I always tell people I don't pull my own teeth. I go to the dentist for that because they know how to do it. While I can pull a tooth out of my mouth, I'd rather pay a professional to do it and make sure that it's done right. So you can do those things. You can download the forms. A lot of them are not state specific. Sometimes they are, or they may be state specific, but it is essentially a legal document that is going to bind your assets to whoever, you designate, if you designate it, if that box is there. But there are certain things that, it's like I tell people, there are certain things you want to use a Groupon on and some things you don't want to use a Groupon on. And I say estate planning and managing your assets and the bounty of your work is not something you really want to take that risk with.
Sounds good. Thank you so much for that. And we've got another comment, and this is honestly one of my favorite guys ever, SoCal Buff. He's reminding everybody to, if you have a trust, to fund it. We haven't talked about trusts yet, but everybody has heard of a living trust, trusts. What is it? And like, when should people actually get one? And what I don't even understand how they work. So
you understand how they work. You know how they work. You did estate planning long before time had a name. When Dodson Legal Group was in its early stages of inception, you did some estate planning.
I may have done a bunch, and I do actually want to talk about asset protection trusts and how that works too. So I'll get there, but let's set the stage. Please tell us a little bit about trusts.
So, a will is fantastic. A will in the state of Texas we're talking about Texas. If you have a will in the state of Texas, it has to go through probate, meaning you have to submit your will to the probate court. They appoint an executor. Sometimes you might have to post a bond and you have to go through all the formalities of filing a very public probate to administer the estate. If you have a trust and you fund a trust and your assets belong to the trust, it's almost like closing on a house. Most of the transfer of assets are done either in a lawyer's office or by the trustee themselves if they're savvy enough to know how to transfer the assets. A trust essentially gives someone the authority to transfer your assets outside of probate court, but within the requirements of that trust agreement. So if you are trying to create a trust, you talk to an attorney, you say, you know what, this is what I want my trust to say. This is what I want my trust agreement to say, because a trust agreement is essentially you're giving someone your assets or you're holding your assets within this trust according to the terms of this agreement. The best way to describe it is I tell people it's like wearing cargo pants. You've got that extra pocket for your chapstick. It's still, your pants, you're still wearing them, but you've got this extra pocket where you can put your stuff. And then when you pass away, the ownership of that pocket transfers, stays in there. It's still your stuff, but someone else manages it and they decide, they don't decide, but they do take over and say, okay, what does the trust agreement say? How these assets can be distributed, and they're responsible for distributing those assets in accordance with the terms of the trust agreement. Someone asked me the other day, well, what happens if they don't? What happens if they don't distribute the assets in accordance with the terms of the trust? Well, if a trustee accepts the appointment of the trust, there's our little doggy. Hi, Lily. Hi, Lily.
Keep going. I'm just hanging out.
Okay. I think she
likes you. Regular office. So I actually wanted to ask you about if you wanted to take care of a pet, like after something happens.
Have your pet spayed and neutered since Bob Barker is no longer on? Are you going to be the one to say that?
Absolutely.
So where did I leave off at? I was talking about trusts, right? And what a trust is. And okay, yeah, I remember. So what happens if the trustee doesn't do what the trust says? Well, if a trustee accepts the appointment of being the trustee and they do not administer the trust and distribute your assets and things in accordance with the terms of the trust, they could be civilly and possibly criminally liable for breaching their fiduciary duty to the trust.
What if I want to take care of my pets after I'm gone? What
Oh,
options do I have?
you can create a pet trust. I just did a video it's on YouTube and TikTok about the Aristocats. It's an old school cartoon where the millionaires left all of their assets to their cats, and they left the butler in charge of managing that trust. But he decided that he was going to get rid of the cats so that he could be the next in line to be the millionaire. So you can't kill off the beneficiaries, and there's a slaughter rule. You can't do that, but you can create a pet trust for your trust. You can designate someone to be in charge of your trust or your pet, manage your pet, and you can set aside some money for that person to manage and take care of your fur babies.
Awesome. And if you don't mind, I'm going to jump in for a few minutes because
Sure.
we talked about, or you talked about, living trusts. They're also called revocable trusts because if you have one set up, you actually still own absolutely everything within it. You're using your social security number, et cetera, et cetera. It's your stuff.
Mm-hmm.
There's also what's called an irrevocable trust, and that's giving your assets to a trust that you don't own the stuff anymore. It's outside of your estates. There's still these trust agreements. There's still a trustee and a process there. But this is the strategy to have a asset protection trust. You put your assets or what you're trying to protect within this trust. Frankly, generally, the way it works is you have a asset protection trust. It is usually managed by somebody that's actually not you. That's something that really concerns people. However, you have that trust owning a LLC or a corporation or some other entity that you are controlling and managing. And so now all of a sudden you've given away your stuff and it's held by this LLC or corporation that's underneath the trust that you no longer own or are involved with. This is the start of true asset protection, because now all of a sudden, if you get sued and they say, we want your stuff, the proper response is, I have no stuff because I don't actually own it anymore.
Correct.
I've given it over to this trust. I don't own it. I don't control it. You can't get access to it. And the secret of asset protection, if done properly, is actually the ability to say, this is what I've done, and you still can't get my stuff.
Mm-hmm.
So it's important to use. What I really wanted to bring up and just share with everybody is you have these revocable trusts. That living trust is there for estate planning. And then you have the other side, which is these irrevocable trusts. That is there for asset protection, or if you want to set up a charitable trust after you're gone, you're giving assets away to some charity, to a church, to taking care of the SPCA, where you can spay and neuter pets.
Have your pet spayed or neutered. Yeah.
Mm-hmm. Yeah, you got it. So I really wanted to share that because it is a strategy to protect if you personally get sued. And that's a different type of asset protection from if you're an entrepreneur and you own a business, or you're a doctor or a lawyer. There are risks in being in business. And you know what? Sometimes the businesses get sued. And leveraging and using a LLC or a corporation allows you to contain those potential risks within the business entity so that you personally can't be responsible for those liabilities, contracts, or other risks. So what asset protection really, there's multiple directions to pay attention to. One being, if you're personally getting sued, how to protect your assets. Another is, if my business gets sued, how do I protect my personal assets? So I just want to bring that up because there's different ways to look at it and deal with it, but it's completely different then the estate planning that is oh so very important that Mrs. Dodson is talking all about.
Yeah. And everyone's situation is different. Estate planning is very personal. And, there's some people that are just like, I don't care. Let my kids play 52 card pickup. We're just going to throw everything up in the air, and wherever it lands, that's where it goes. And some people, have that strategy, but it really is a burden on your loved ones. It's, I always use the tagline, don't leave your dirty dishes in the sink, because somebody's going to have to clean it up. So there are things that you can do during your life as far as estate planning goes, like Nate was saying, to make sure that your assets are protected for your beneficiaries. But then if you're going through all the asset protection for yourself during your life, you need to make sure you have them protected for your loved ones when you pass away. So, they kind of go hand in hand. You got to do the asset protection and the estate planning. And asset protection isn't for everybody. There are some people that, you may not need asset protection. And there's some people that definitely do need to set up some asset protection, especially if you're involved in any type of business that's going to cause or create liability. While the LLC is definitely that first step to try to limit liability and make sure you're operating under that LLC. If you're in a business where you anticipate being sued, if you're making a lot of money, chances are some people think that they can easily get that money from you by filing a lawsuit.
Well, let me just say that you don't go into this thinking I'm going to get sued, but the reality is if you have a long enough timeline, a career, a business that's going on decade to decades, on average, somebody or the businesses get sued about once every 13 years. It is at least what the averages are. So it's not a question of if, it's just a question of when. And that's the reason to plan ahead. Don't plan for once you get sued, because generally once you get sued, it is too late to do anything. This is something that you need to plan way in the future, even before you think there's a potential problem.
Yeah, this reminded me of a case I had back when I was in Las Vegas. When I was in Las Vegas, I did a lot of insurance defense, and I represented insurance companies, mainly trucking companies. And I remember one of my clients, I met with him, and he had this beautiful ranch, and he also had a trucking business on the side. And I was talking to him, and he was actually named individually in the lawsuit because one of his drivers got into a motor vehicle accident. And it's because that he owned all of his vehicles in his name and not necessarily in his company name. And I had a long conversation with him about exposure. I said, hey, you've got these things in your own individual name. That's opening everything up in your name to get sued. If somebody sues you and you own your home, you own your ranch, you own these trucking companies, you own all of these other things, all of that is exposed. So, like I said, that first step is getting that LLC for your business, so that if something goes awry with your business, then you are in effect attempting to limit that liability to that particular business and not open up everything else that you own and expose, everything that you've worked for.
And I'm excited because I actually have a story that goes right along with your truck company, but it's actually not my story at all. It's one of the most famous corporate law cases that kind of has to do with asset protection.
Okay.
And it applies very much like that trucking company, or if you own multiple locations or multiple little components of your business. Mm-hmm. It was back in the 30s in New York, and you had a cab company. This cab company set up different corporations for every single cab that they had. Very similar situation to what you're explaining. There's a car wreck. And of course, whoever got hurt sues the cab company, sues the owner, sues absolutely everybody, because that's the way litigation goes. And the cab company got to say, no. That business that owns the cab that's responsible is this corporation that only owned this taxi, and that's it. And actually, that was really one of the first big cases that Well, the court said, nope, you are absolutely correct. It doesn't matter that there's this holding company and all these individual LLCs or corporations. It doesn't matter. You are still protected other than that corporation that actually had the assets and had the liability that caused the injury. So I actually had a legal, I am an attorney, I promise.
So I'm assuming the only assets that that corporation owned was the vehicle.
You nailed it. But going along those lines, and I do want to mention, if you are setting up one of these structures, and I used to help people all the time doing these things. Nowadays, instead of setting up 50 different LLCs or 50 different corporations, we'll do like, it's called a series LLC.
Mm-hmm.
And a series LLC is like a single LLC that you're creating all the subsidiaries and everything underneath it. But regardless of which direction you go, definitely get that legal advice on how to do things properly, because there is this risk, they call it piercing the corporate veil, that you have to treat each company like it's actually a company. And this applies for all this asset protection, the trusts, the LLCs, the corporations. You got to treat it like it's not part of you, not your alter ego.
Right.
Otherwise, a court can just pierce right through it and say, nope, you are actually still responsible.
My real estate investing clients love series LLCs, the ones that are really big on the single family rentals. So what they'll do is they will create a series LLC, and each rental property has its own LLC that owns that rental property. And it's structured in such a way to where, yes, they do have multiple LLCs, but each LLC is limited to the property that it's associated with. So yeah, series LLCs are used in estate planning as well, because then essentially we create a holding company and then we transfer that holding company to the trust. So anything that is created underneath that is already trust property. So yeah, we love a series LLC.
Well, thank you so much for sharing. And if anybody has any final questions, please ask. Otherwise, Jasmine's going to sing us a song.
I'm not going to sing a song.
You promised.
I did not promise. Yeah.
Oh, well.
Not today. Different venue, honey. Different venue.
Maybe get up and do the hokey pokey and
I'm not doing a hokey pokey. You can dance if you want to. I'm sure that everyone would love to see you dance. And don't you call yourself a dancing monkey sometimes when you do your presentations?
I am a dancing bear, absolutely.
Dancing bear.
Because
Got it.
yes, I'm there to. I'm here for you, baby. Anytime you need a dancing bear. So, but do you have any final thoughts or final things before we close up shop?
Actually, I do. So for individuals that may be just getting started and may think, I can't even afford to hire an attorney to do a power of attorney or medical power of attorney, anything like that. There are other ways that you can make sure that the assets that you do have are protected. One of the very basic ways is if you have a bank account, make sure your beneficiary card is filled out. Make sure you identify someone to own your bank account. Or if you pass away unexpectedly, you've designated a beneficiary, it goes straight to that person without being in probate. If you own real property, the state of Texas has something that's called a transfer on death deed. If that's your only one and only biggest asset, fill out that transfer on death deed and get that recorded against your property, which turns your real property into a pay on death benefit. So the first step that you want to take is to make sure that you are maximizing these direct beneficiary accounts or these pay on death benefits, similar to life insurance. You identify a beneficiary on your life insurance, your 401k. Make sure those are up to date and they go to who you want them to go to.
Perfect. Well, really appreciate your time today. Thank you so much, Mrs. Jasmin Dodson.
Thank you for having me on your Facebook Live.
Oh, absolutely. Okay, we got one more question.
Okay.
What happens if you don't designate a beneficiary? Who gets the money?
So if you do not designate a beneficiary, then it defaults to the estate of. So we'll just use John Doe as an example. John Doe has a bank account with, let's say $15,000 in it. John Doe passes away without designating a beneficiary. The bank will send that to the bank will hold that in the name of the estate of John Doe. If no one claims it in the state of Texas, it goes to unclaimed funds. So that's a fun project. If you're looking for, maybe a rich uncle or something that may have passed away, you can go online and search the state of Texas unclaimed funds, and maybe you can find yourself some little extra money. So, but there is unclaimed funds, and that's where they may end up going, because it's not going to be worth it to open up an estate to just get the money that's in there.
Which leads me to my own one more question. What if I don't
Sure.
do any of this stuff? I don't have a will. I don't have a trust. I don't have any estate plan. And then I die. What happens to my stuff?
So the state of Texas and most other states have something that's called intestate distribution. And that's a fancy legal term for everyone else, all of my heirs gets my stuff. So the state of Texas has provided I guess it would be a distribution schedule for who gets your things if you pass away. So generally it's the surviving spouse. If you're married, community property goes to the surviving spouse. Unless you have kids from a previous relationship, then everything goes to your kids. So your community property share would go to your children instead of your surviving spouse. And then it goes from the heirs underneath that. Like, so your kids have kids. And then if you don't have kids, it goes back up to your parents and then your siblings and their kids.
Truly appreciate it. Thanks for confusing us all with what the happens without a will. Well, thank you all for joining today. I hope you learned a thing or two. Don't forget to spay or neuter your pets or the strays.
Oh, Bob Barker's just going to love that you are keeping up his tradition of spaying and neutering your pets.
He lives on through all of us. So thank you all.
Thank you.